Good evening. This is Rahul Reddy. Reddy Neumann PC comes live every Tuesday from 5 to 6 p.m. We bring in immigration updates every Tuesday from between 5 and 6 Central Time. Emily, what do we have today?
All right, today, obviously, the coronavirus is the hot topic. And so, the situations that arise really have a much more drastic impact on immigrants, even legal immigrants that are here or trying to come here. So we want to give you updates and answer questions that you have about travel, visa appointments, filing with USCIS, what happens if you need to work from home, how does that impact your status, online courses for F1 students. So we want to talk about all of that and answer your questions as best we can. We also want to discuss the new public charge rule that just went into effect last month and how it is going to impact specifically dealing with coronavirus and seeking medical attention. Is that considered a public benefit right now? And updates on the H-1B electronic registration process, how that's going. The deadline is coming up on Friday. We have some information about premium processing and how that's going to work and when you should expect your results.
Well, we're sitting far away from each other, just trying to be protective of each other. You have seen that in the presidential debate also, both presidential candidates were a bit way far apart when they were in the debate. Also, we noticed that the persons who are asking questions were a little bit too closer than what they are supposed to be. So we're taking our precautions. At the same time, of course, we recommend that you contact, you go with the advice of the WHO or the doctors. We are not the persons who are going to be giving you any advice on the medical issues, though. So let's discuss on the issues of the immigration, Emily. Now we have things, all the things have changed right now. Visa appointments are canceled. Is it canceled? What do? They need to reschedule those visa appointments right now?
I think that we don't know because we don't know how long this is going to last. They canceled several as of yesterday, different consulates, particularly in India. And so it's unclear whether they will automatically reschedule or send you a notice allowing you to reschedule once they do reopen. But as of this point, many consulates are canceling visa interview appointments.
So most probably they don't have to pay the fees again. You most probably would not have to pay the fees again, but they will allow you to reschedule you once the things open. Definitely I do not expect the government to ask you the money again. So if you are planning to go for any visa status change or something like that, you may want to put that on hold, look into the alternative things. Maybe you need to file an interim B2 application if by any chance you're going out of status, or you may want to extend your existing status if you are in a particular status. If you are already violating the status and you have to go and get the stamping, you may want to consult a lawyer with regards to what are the options available. I just want to state the law. I'm not telling you what to do. If a person is unlawfully present in this country, if it does not cross more than 180 days, then they are still eligible to file they're still eligible to apply for the visa statuses. But if the unlawful presence crosses more than 6 months, that's 180 days, they will have a 3-year multiple, they will have a 3-year bar. So if the person is unlawfully present for less than 180 days, they still are fine. They still can apply for the visa. We're not telling you to do something, we're just trying to quote you what the law is. Now, coming to the work from home is concerned, Emily. What's going on the work from home issue? So if a person is an H1, if the person is an L1, can they work from home or can they not work from home?
Yeah, so this particularly is important for H-1B holders because you are tied to the workplace that is mentioned on your LCA, your labor condition application. Now, for most people, if you live near where you work, your LCA is considered valid if you live and work in the same metropolitan statistical area, that's typically the same county, or at least a reasonable commuting distance if you live a reasonable commuting distance from the office where you work, that LCA should remain valid to allow you to work from home. Now, if you commute a large distance to the office every week and then travel home on the weekends, we see that quite often. So say, for example, you work in New York, but you actually live in Houston and you're wanting to work from home from Houston while you're in H-1B status. Typically, any work location change that's outside the normal commuting distance, outside the metropolitan statistical area, requires an H-1B amendment to be filed before you can start working at the new location. There is, however, a short-term placement provision that can allow you to work in a location that is not mentioned on your LCA for up to 30 work days or possibly even 60 work days in a 1-year period if certain requirements are met. So that may be sufficient to allow you to work from home just for a very short period of time. Once you hit that 31st day or 61st day, depending on whether you meet the requirements for 30 or 60 days, if you're still working from home at that point, an amendment has to be filed. So the idea is during this 30 or 60 day period, if it looks like things are going to extend beyond that time period, start the process for getting that amendment filed. For L1s, typically a location change is not going to cause, it's not considered a material change, so it's not going to require an amendment. For F1, for OPT and STEM OPT workers, you may want to contact your school to let them know, especially if it's outside your normal commuting area or if it involves a change in job duties for you to work remotely versus working on site. You should probably check with your school to see if an updated I-983 might be required for that process. So that is the main issue for working from home. It particularly is going to be impacting the H-1B individuals who work very far from where their home is, where they're planning to stay and work remotely from home. We also have issues with people that need to file an extension of stay, particularly in the status of B2. If you have someone who's here visiting, typically they're here for a 6-month stay, and if you can't leave during that time frame, it may be necessary to file an I-539 application in order to extend the existing B2 by up to 6 additional months. That has to be filed before the current stay expires, before the current I-94 expires, in order to be considered timely to allow you to lawfully remain in the country. So keep an eye on that date and make sure it gets properly filed by the deadline of your I-94 expiration. It's a little bit different for those that are here on visa waiver program, because there you only get 90 days and it's not possible to extend the visa waiver program by filing an I-539 application. You need to contact deferred inspection of your local CBP office to see if you can qualify for. Right now they're only giving a 30-day kind of extension period for you to stay beyond that 90 days, and it's kind of very strict requirements for that. They require extreme, unusual circumstances, so you'll have to contact CBP for that option. So we're also seeing, with universities here, those that are in F1 status and attending classes, the schools are sending everyone home and moving everything to online classes. You know that F1 students generally are not eligible to do online courses, but for this particular issue at this time, USCIS or ICE actually has put out a update that they will allow F1 international students to take online courses if their school is requiring it due to the coronavirus situation in order to maintain the safety and health of all of the students. So those are kind of the main issues that we're seeing right now of people being impacted by the situation. In addition, we talked last week, we had the topic was what happens in a recession, tips for those who are in non-immigrant status, those that are skilled workers here legally. Those are some things that you might want to consider looking at again. We're starting to see, with things shutting down, there's less work available. We're starting to see some early cuts being made to jobs, so that's something to keep an eye on and understand what your options are there. You do have a 60-day grace period if you're in H or L status to potentially find another employer. You may be able to return home and work from your home country if that's an option. And potentially come back later once the economy recovers. So take a look at last week's video where we discussed some tips on that for extra information. One of the other topics we wanted to talk about is this new public charge rule that just came out last month. It basically says that if you are intending to apply for an I-129, for an I-539, or an I-485, the form now requires you to answer whether you have received public benefits since February 24th of 2020. So the question becomes, well, if I'm using these, if I need to go and get tested for the coronavirus and the federal or state or local government is doing that free of charge, or maybe, God forbid, if you actually get sick with coronavirus and end up in the hospital, and that treatment is covered by the federal government or by the state or local government, how does that impact you when you're later filing your I-129 extension, I-539 extension, or your I-485 for your green card? So USCIS has come out and indicated that they will not consider coronavirus medical treatment or preventive services to be taken into account for purposes of determining whether you are subject to the public charge ground of inadmissibility. So there is an update on uscis.gov about that, so definitely make sure that you check that website to verify exactly what is covered, what isn't covered under that provision, so that you can ensure that you can get the treatment and services that you need without impacting your future status.
Emily, so are you telling that they can work from home right now? For the next 30 days, they can work from home?
Correct, as long as the short-term placement provisions are met for that to happen.
Okay.
There is a very clear fact sheet from the Department of Labor. If you Google DOL fact sheet short-term placement, you'll be able to find that, and it spells out exactly what the requirements are for you to qualify for that, as well as the extension to up to 60 work days. On that.
So what about if somebody gets a coronavirus? Is that an excludable grounds for them? Will they be deported if they are in legal status in the United States?
No. So once you could consider this maybe a health ground of inadmissibility, but the health ground of inadmissibility only applies if you are at the consulate or at the port of entry coming in. So if you're applying for the visa or coming into the U.S. and they see that you're, potentially sick, they could choose to exclude you and return you to your home country according to the health ground of inadmissibility. If you're already here, that is not a reason for them to deport someone. So they should not be deporting people simply because they're here legally and then get sick with the coronavirus.
Okay, and in the 30-day requirement that they can work from home, you said that 60 days under the circumstances where they're heavily connected with their LCA, where the LCA has been filed, they should be fine.
Yep.
So if it goes beyond that, maybe USCIS might come up with a different policy, or maybe we have to file for the H-1B extension. Any of those things could happen. H-1B amendment that can happen.
Correct.
Emily, on the H-1B electronic registration, now everybody's interested in it. Any news from the electronic registration? What is going on that?
So after some initial hiccups, they seem to have corrected many of the glitches that were happening, and so it's been quite smooth since then. And Friday is the last day for the registration to be submitted. Again, only the employer can register someone in the lottery. After that point, by March 31st, USCIS will conduct the lottery electronically and will update the status of the case in the My USCIS system of the employer. So only the employer and their attorney will have access to see whether a person's registration was submitted or selected or not. And if it is selected, There will be a notice there with instructions for when to file, which should be between April 1st and June 30th, and what service center to file in. So keep that in mind, is with this electronic process, USCIS will tell us where to file the petition, which may be different from where employers typically file. They're likely to kind of spread them out between the different service centers, California and Vermont, so that they can balance the workload. So companies that normally file in Vermont may be asked to submit certain petitions, or maybe all of the petitions in California, just depending on how the numbers work out, and the other way around as well. So March 31st is when employers and their attorneys should find out who was selected, and then you can begin filing petitions April 1st. Deadline to file is June 30th. Remember, if you are needing the cap gap and your OPT is expiring before June 30th, you need to have your petition filed by the time your OPT is expiring. You can't wait until June 30th. You have to file before your OPT expires in order to qualify for a cap gap.
Emily, can an employee not find out if his application has been filed or not filed? Is there any way he can look into and find
No.
out? There's no way to find it out.
No,
Okay.
no access at all for employees.
Okay. And let's go to the question and answers.
One update on premium processing.
Yes,
We did
I
get that
forgot about
announcement yesterday that USCIS will not allow premium processing for any of the cap subject filings that are submitted from April 1st to June 30th. However, this is temporary. They do expect by approximately May 27th, they may allow premium processing for change of status petitions, which is what they did last year. They had kind of staggered windows for filings. They delayed all of the premium processing, and then when they did make it available, it was only for change of status applications, so that they can focus on particularly the master's cap and getting those that need the cap gap extension approved by October 1st. So you may consider delaying filing your petition until premium processing becomes available, if that timeline works for you, or you could file it before and then upgrade later. Again, only the employer or the attorney can submit the premium processing or upgrade the case to premium processing. The employee doesn't really have control over that.
And the question that comes from YouTube is, if my parents' I-94 is expiring in March 30th, and I don't want to send my dad to India right now, what is the best solution? Should I file an extension of the B2? If I file an extension, I might not even get the receipt notice. Can my dad stay in this country? And since they're not going to approve the application by March 30th, can they still stay in this country?
Yeah, normally we don't recommend filing an extension of B2 status, but here we're kind of in uncharted waters and new situations, and you might not have the option to leave by the time your I-94 expires. So if you're wanting to file an extension, the I-539 must be delivered to USCIS before the I-94 expires. As long as it is properly and timely filed before the I-94 expires, the parent will be in a period of authorized stay. They can remain in the country while the extension application is pending. Now, you only can request a 6-month extension. So if at the 6-month mark that extension is still pending, which is very, very likely given the current I-539 processing times, they will have to depart the United States at that 6-month mark even before the decision is made on that.
Emily, if a person has been denied the change of status because they are going to the day one CPT university, and now they have to go for stamping, what do you tell them to do right now?
Oh, that's a good question. So first I would be checking with the school to determine whether your SEVIS record is active or if it's been terminated. Most of the time the SEVIS record is terminated due to the violation of status and the denial of the change of status. So in that situation, you are out of status in the United States, and there has been a determination made that you violated your status, and unlawful presence can kick in from that point. So you have to make sure you're not crossing 180 days. You may have to go out and wait outside the country until you're able to schedule a visa interview to get the H-1B stamp and come back in, which is why we generally, at least last year and this year, are recommending, if you're in one of those day one CPT schools, to not request the change of status. File the H-1B petition in consular processing so you can avoid the denial of the change of status, putting you out of status and forcing you to leave the United States before you're ready to and before this whole coronavirus issue is resolved.
Today we're going to take as much questions as possible on the coronavirus and the delay and the problems that it's going to cause for the non-immigrant visa people. That will be the main concern for us. So we'll take the other questions too, but mostly about the coronavirus. Padmaja from YouTube has this question that she is in Chennai right now. Her interview is scheduled, which has been cancelled, but her biometric is not cancelled. Should she go for the biometrics? The answer to my question, Padmaja, is if you feel physically safe. I mean physically safe is that if your doctor tells you that you can go, I think so you can go. I will leave it up to the doctor. If you cannot go because the biometrics is still scheduled and you cannot go, I want you to drop an email to the consulate saying that I cannot attend the biometric. I want you to postpone the biometrics. There is a, even though they did not cancel your biometric, I have a good doubt that they may cancel your biometric too. But if your doctor says yes, you can go, yeah, you can go. That's fine. I'm fine with it. You can go. It's not going to cause any problem. But if you're not going, please inform the consulate that you're not going.
Bhagavan from YouTube is currently in the 60-day grace period after a termination of employment and recently got a new job offer and wants to know if he needs to have the transfer approved by day 60 in order to start working for the new employer, or if he can start working based on the receipt notice. So these 60-day grace periods are likely to become more common with the situations going around with the coronavirus and recession talk happening. So to answer your question, as long as the transfer petition is received by USCIS by day 60, you can start working for the new employer, and it's considered that you've maintained your status the entire time, as long as your I-94 does not expire before day 60.
Lee wanted to go to Vancouver for visa renewal so that he can apply for the EAD, but now with the virus, Canada stopped entry. What do we need to do? Do we support the EAD litigation here in the United States? Yeah, you can apply for a H4 plus EAD, and then you can join our litigation. By the way, even if you go and get the H4 stamped in, you come back, if you apply for the H4 EAD, it's taking about 4 to 8 months to get an EAD approval. So I would rather recommend that you stay in the country, apply for the change of status, and apply for the EAD, and then join the court litigation. That would be much better. And we take approximately about 40 to 50 people every other week to the court to get their things adjudicated faster.
Ida from Facebook wants to know, if someone got the coronavirus, does it affect the person's medical exam for the 485 application? Can they deny the form I-485 if the person is affected by coronavirus? That's a really good question. And I think it's too soon to really give a definitive answer on that. But I would say
I think so. I can guess the answer, but correct me. Later on, you may want to check with us on the later things. Is that viral is a temporary thing. It shouldn't stay in the body. I might be wrong. Have the doctor corrected me, but I got a couple of virus before, and then it just left. It doesn't leave a permanent mark. However, though, my wife told me, who works in healthcare industry, that this virus is a little bit different than that of the other viral. It may stay in the body and it may come back again. So
yeah, I think what I would suggest, if you are required to file your 485 while you have the coronavirus in order to basically maintain your status, don't submit the medical exam at this point. You can file without, and then they'll call you for the medical exam later. That could be a year from now, and hopefully by that point you've recovered and there's no virus there and you should be fine.
One quick question from Janai Patel from YouTube, Emily, is I need your attention here is that will they extend the deadline beyond March 20th to file the H-1B lottery system?
I highly doubt it. I would not.
Janai, I would
USCIS
not want you to count it because it's nothing physical application, it's an online application. If I were you, Janai, I would not, because you still have 3 days left or 4 days, 3 days left. You can still file the application. Don't wait. For sure, don't wait on that.
Kella Rossi from Facebook has an extension pending right now. He wants to know if he doesn't get the approval within 240 days, what needs to happen, especially given the current situation. So there's very little reason that an H-1B will continue to be pending for 240 days because right now we have premium processing. So upgrade to premium processing, avoid that possibility, and you don't have to worry about it. But generally, if this is an extension that is filed with the same employer under the same terms and conditions, your employment authorization is only valid for 240 days. From day 241, if you do not have the approval, you have to stop working. You can legally remain in the country in a period of authorized stay, but you can't work after day 240. So don't get into that situation, just file it in premium processing.
Bhagwan from YouTube has this question. He's in 60-day grace period. He will be able to file the H-1B, but does he need to have a approval? Does he need to have a receipt notice? Bhagwan, if the USCIS has received your application, you can track that mostly by FedEx tracking number. You can start working, and that should be done within 60 days. It doesn't have to be that you must receive the receipt notice in your hand. You can work based on the FedEx tracking number your company allows. Normally companies do allow. You can, based on that, you can start working on it. You don't have to have an approval within the 60 days for you to start working.
Suketu from Facebook wants to know if we are told to stay home without pay due to the coronavirus, if you're in H-1B status, is that okay? Unfortunately, the answer is no. There is no benching allowed when you're on H-1B. If you are available for work, your employer is required to pay you in order for you to maintain your H-1B status. If you are in that situation, you may need to consider transferring to another employer or potentially exiting the U.S. if you don't have that option, so that you don't fall out of status.
Emily, what about the student visa people who are trying to enter into United States? If their college is starting immediately, what should they do right now? Now, since the visa appointments are all canceled.
You could if they don't have the visa yet.
No.
You could potentially travel to another country where visa appointments are available, get the visa stamped, make sure you wait the 2 weeks because they're looking at the 2-week period prior to your arrival in the U.S. So if you have that option of traveling to a different company that's not currently, a different country that's not currently restricting visa interview appointments, that might be one option, and then wait the 14 days to travel to the U.S.
One of these suggestions or the questions from the YouTube is that will this delay the processing timings of the USCIS on the H-1B and on non-immigrant visa? I bet it will. I'm sure it will.
Yeah, right now we haven't seen much difference. There's really been very little action that USCIS as an agency has taken. They haven't really closed any offices. They're still conducting interviews, which is kind of a little surprising, but I think very soon we'll start to see processing times increase. Vivek from Facebook, kind of along those lines, wants to know if USCIS is still accepting applications at their lockbox facilities and at the service center, or have they made any changes because of the virus. They have made 0 changes to filing procedures. We don't know if they will. As of this moment, it doesn't seem like they're planning any major changes to the filing process right now.
Will there be any delay, Emily, with regards to getting the, we told many times that most probably by March 31st, they should conduct the lottery. Do you think so there might be any delay in it?
I would not expect there to be, because again, this is all electronically done. So people hopefully with USCIS can monitor these things and run the lottery from home if they had to. I would not expect that to be delayed.
Question from Vinod Kumar from Facebook is that as a completion of the US Master's degree from India, will it qualify for under EB2 if it's completed in the USA? Vinod, the question mainly comes is that is it an accredited university? A lot of the universities that do offer the online courses in India, we don't see them as accredited universities. They should not only be accredited, but they should also be non-profit university. If they fall into both criteria, though, they should be able to accept the online degrees. I don't see any problem, do you?
No, as long as it's accredited for I-140. Dip from YouTube wants to know, due to the coronavirus, we are asked to work from home indefinitely. And when it's time to file the H-1 extension, what do we do about the job location? Do we list the home location? Do we still put the client site location? Where do we do the paper notice posting? It's a really good question. So I think that it will depend greatly on kind of what the plan is in the future. You have a couple of options. Option number one, both work sites could be listed on the LCA, and you post the notice of filing in your living room or in your home office or wherever you feel like, on your fridge at home, to cover the home work site. If you do have both locations listed, know that an itinerary is required to be submitted with the extension filing. So that will have to be explained why there are two locations listed. You have the option of listing, again, only the client site if you're working from home that is within the same metropolitan statistical area, or you could put your home location and then later move to the client site if it's still within the same metropolitan statistical area.
Srinivas from YouTube is on a green card status. He wants to know if he applies for the unemployment benefits, will it cause any problem for his citizenship application? No, it will not cause any problem for your citizenship application. The unemployment is more like an insurance that you're applying for which your company has already paid for it. So I don't see any problem in your citizenship application at all.
So Rob from Facebook says his H-1B transfer application is on its way to USCIS, and he wants to know if the coronavirus situation will affect anything or cause a delay in premium processing. So at this point, that generally is not likely. In the past, whenever premium processing has caused issues or they haven't been able to handle the premium processing cases, for the most part, they will set a specific future start date of when they will stop accepting new premium filings, and they'll process those that have already been received. There was one time period I remember where those that had already been filed in premium processing, they tried to process them in premium as much as possible. Those they couldn't get to, they mailed a refund check if they couldn't process it within the 15 days.
Anusha from YouTube has this question. Because of the COVID virus, if somebody stays unlawfully in United States after the I-94 expires, can we give a reason saying that because of the virus I was unable to get out of the country? The answer is yes, Anusha, you can. I want you to reiterate the law that if a person is unlawfully present in the country for less than 180 days, they are still allowed to go ahead and apply for the non-immigrant visas. There are many situations we see, especially when it's an advanced stage of pregnancy, and sometimes people just fall out of H-1B extension gets denied and they need to pack their bags and leave. And if they say it's a reasonable amount of time, not nearing 180 days, we haven't seen a significant amount of problems with regards to consulate issuing the visas. Now, we are not supposed to, as immigration lawyers, we cannot tell you that you can stay undocumentedly or unlawfully in this country, but I'm just telling you what the results are. Especially in the situations like this, let's say your I-94 expired and now you can't go because of what is going on. You don't want to go also in this situation. If I were you, I would be perfectly fine. Now, what if the situation stays like this for more than 180 days? That's going to be a miracle if that happens. There are a lot of problems the whole world is going to face. So we'll please keep updated with this YouTube and Facebook, and then we will update you. But at this point of time, we're expecting that this will fade away in 2 to 3 months, and you should be able to leave.
Vinny from Facebook wants to know if you can file an H-1B transfer after the I-94 has expired where you have an approved I-140. So generally, you need to file an H-1B transfer before the I-94 has expired. USCIS does have a special provision if the delay in filing is due to an extraordinary circumstance beyond your control and beyond the company's control, and the delay is a short delay that's commensurate with those circumstances, and you've not otherwise violated your status, the new company could try to file a transfer under those situations and make the argument. That's called a nunc-pro-tunc request. USCIS may or may not agree with the nunc-pro-tunc request, and if they don't, they'll issue the H-1B approval without a new I-94 card, meaning that you are out of status. That means you've been unlawfully present the entire time the application was pending, because you're already unlawfully present from the day your I-94 has expired. So you have to be very careful about the 180-day clock. If you're going to attempt this, if you actually meet the requirements of the nunc-pro-tunc request, it has to be filed in premium processing so that you can get the decision before day 180.
Boneslav from YouTube has this, Facebook has this question that can he move from a contracting company, can he move from the end client company to a contracting company within the same, with the same position and file a H-1B and start working? Yeah, I don't see anything wrong in it. Technically, legally, that's perfectly fine. Another question that pops up many times in YouTube and Facebook for us is that, I see many questions, is that can we file duplicate applications for the H-1B quota? I have a contracting position and I have an in-house position somewhere else. We consider that completely illegal and completely, it's a crime. You're also contributing to the crime. I think so you are a co-conspirator if you would cooperate on this particular thing. In fact, I just got off phone with a gentleman who got into trouble because of that. Yesterday, I got off phone. I had a consultation with a consulting company that they have filed many in-house projects and now they are issuing an intent to revoke. And I think so there is a criminal prosecution that is going on behind them too. And this is very common that we receive it. Calls from the employers and employees getting into trouble. So if you are going to file multiple applications in this new quota, even if they are different companies, we consider it at Reddy Neumann PC as a crime and you are a conspirator to the crime. We tell people to stay away from it completely.
Prashant from YouTube says his H-4 extension documents reached USCIS on March 14th. The I-94 expires coming up soon on March 23rd, and he wants to know if it's legal to stay in the country if you do not have the receipt notice by March 23rd. So the requirement is that the application must be timely filed and properly filed. It can't be frivolous. So assuming that it was properly filed and it actually was received by March 23rd, you can remain in the U.S. based on the pending application, even if you have not yet received the receipt notice in the mail. That being said, I would be checking to make sure that everything was properly filed, that the filing fee check was proper, filing location was proper, double and triple check everything. Keep an eye on when the filing fee check gets cashed. Usually it's within a couple of days, maybe 5 business days of when the application was received. So hopefully you will see that check cashed before March 23rd. Then you know it's safe, it was properly filed, and you don't have to worry.
Jay is informing that LA field office is not accepting the mail. Contrary to the comment that we made, it may be true, it is true. Normally most of the applications, Jay, that the business immigration field do file in the service centers or the lockbox. Of course, there are some applications that we come across responding to the RFE, sometimes to the field office. Yes, some of the field offices are not accepting. Thank you for the information, Jay.
Let's see. Anusha from Facebook recently had an H-1B denied and the I-94 has expired, and she wants to know if you can refile using the nunc-pro-tunc argument, or do you need to file it using consular processing. So it really depends on the circumstances and how long it's been since the I-94 has expired, how quickly can you get the new petition filed, is there an extraordinary circumstances argument that you can make. So if you choose to file the nunc-pro-tunc request, make sure you get the decision before 180 days so that you don't end up getting the 3-year bar. Your other option is, of course, to go ahead and request consular processing to avoid having a determination made that you are out of status and unlawfully present. But of course, consular processing, you may not be able to get the visa stamp in the near future based on consulates not being doing interview appointments.
Karthik has this question: does the IT Server Alliance litigation, is that for all H-1Bs, so, or only for the particular H-1B applications that have been filed? Karthik, I just want to reiterate that I am one of the founder of the IT Serve organization, proud founder of IT Serve organization, also proud member of IT Serve organization. But unfortunately, the court decision is only applicable for the cases that were being filed by the IT Serve Alliance. However, though, IT Serve is taking to another level to have this one applied to each and every H-1B. They are intending to file in the service center jurisdiction so that they can force it on each service center. That is their plan right now, because they don't want to just keep on filing their H-1Bs, getting the denial, and they don't want to go to court for every H-1B denial. They want to restrain the USCIS by filing the cases in the district courts where the service centers are there, and restrict the service centers to implementing those kind of memos. They are actively working on it. Karthik, but at this point of time, it's only applicable to the applications that were involved in that particular lawsuit.
Shankar from Facebook has a question about that 30-day short-term placement that we were talking about for working from home. So his question is the work from home limit for H-1B 30 consecutive days or all year? So first I want to remind you that the limit on working from home, this 30 or 60 days that we've mentioned, is only in the situation where your current LCA does not cover your home location. If you're, working in Houston, Texas, and you live in Houston, Texas, you can work from home while you're on H-1B without the need of filing. There's no 30-day limit. But if you are working in New York and you live in Houston, Texas, then you are limited to 30 work days in 1 year. So let's say that you are going to work from home 3 days a week and go into the office 2 days a week. You can do that for basically up to 10 weeks within 1 year period and still be able to qualify for the short-term placement provision.
Maya has this question: the family-based 485 application is sitting in Chicago for several weeks and no receipt notice has been generated. Maya, yes, I've seen the same problem in our office too. It's been almost 30 days, no receipt has been generated. I don't know what's the problem with Chicago is, but check back with us next week or drop us an email next week. We will be able to guide you better on that. Especially we have seen that when the 24th deadline was coming, that is February 24th, they started introducing new forms called 1044 forms were being introduced. I might have told the wrong number of the form, but when they got this public charge thing coming on 24th, a lot of applications were being filed just before that date, and they're holding some of those applications without issuing any receipt notices. We have noticed that.
Vicky from YouTube has a question. There's been a lot of talk about the government just mailing checks to people in the United States to help them deal with the coronavirus situation. If you are a non-immigrant, an H-1 worker, L-1 worker, and you receive one of these checks under this economic stimulus, could that be considered a public charge if you actually were to cash one of those checks? That's a good question. I don't know if we have an exact answer for you yet, but the generally what the public charge rule is trying to prevent people who are using the government for income maintenance, meaning a long-term period where it's SNAP program, TAMF program, HUD housing payments that they're receiving. So there are a list of very specific government agencies and where these checks are coming from, and it's when you receive them over a long-term period for income maintenance. So I think a temporary one economic stimulus check is likely not to be considered a public charge. I don't know if you have anything to add to that.
Yeah, and the other thing is that most probably we're expecting that either they're going to cut the payroll taxes, that means that you're going to receive more check in your payroll, or they may refund some of the taxes that you have paid to the government. Either of those situations, you will perfectly be fine. Absolutely, you will not be in any trouble. I also want to warn people that if you just get a check and it says the US government, check it very carefully because they may ask some of the information about you and cheat you though. I just want you to be very careful. Does it come from an authentic source? Check it out on the internet. Looks like a genuine check? Before you deposit it, make sure that you have all that information. You just don't try to give the information to bad people, all your bank information. One question from Sunil from Facebook has this question, is that he's working from a clinic outreach. He goes there every other week and just spends some time there. Does his employer have to have an LCA from the second location also? One thing is that if it is within the same MSA, you are fine. You don't need to have an LCA. If it falls beyond that MSA, which is within, I'm understand. It is my understanding, Sunil, that you know what MSA is. If it falls beyond that MSA, though, there are certain requirements, as Emily has pointed towards. Is it been more than 60 days in a calendar year that you are actually going to that particular location? Then definitely it will cause a problem. Is it a straight 30 days that you're going to that particular location? That will be a problem. But I would still want you to check. If it's out of the MSA, I want you to check with a lawyer to make sure that you're complying with the law.
Vishal from YouTube says his father came to the U.S. on a visitor visa before and has already filed for a B2 extension and gotten that approved. Now that approval is expiring March 23rd. What are the options? We don't want to send him back home due to the coronavirus situation. I'd say it's generally pretty tough to get a second B2 extension approved, but I don't think you have a choice. I think you have to file it or have him leave by March 23rd. Those are your only options.
Yeah, the second extension definitely is a very dangerous extension though. Because they don't understand why the parents visit the children for more than 1 year. So it's not the common culture for them to have the parents visit the kids for more than 1 year. We are in this country and we can't impose our culture here. So please be very careful in whichever step that you do. It may impact in their coming ever into United States. We normally don't recommend people to file a B2 extension beyond 6 months period. But of course, in the extreme circumstances like this, it may be fine, but now it's more than 1 year. That's very dangerous though for them. And especially, yeah, you can extend it, but most probably you might forego their coming into United States forever.
Arvin wants to know, he saw the note about temporarily suspending premium processing on the USCIS website. He's filed for an extension using premium last week and wants to know if it will be considered for premium processing. So that premium processing suspension is only for cap subject H-1Bs, those that are going through the electronic registration process right now and that will be filed between April 1st and May 27th. It does not currently impact extensions or transfers or amendments or any other type of H-1B that's being filed right now.
Svarup from YouTube has this question. taking personal loans, comes under public charge? No, it does not come under public charge. Lakshmi from Facebook has this question: can a visitor visa be extended without biometrics? The answer is no, you cannot. Even though they have given biometrics before, they still need to give biometrics again.
Anoop from YouTube wants to know if the perm processing will get further delayed due to the coronavirus effect. They've already backlogged by 5 to 6 months. It's a definite possibility. I mean, they haven't announced anything as of right now. The good thing with the perm process is everything is electronic, online submission. But I think you can expect anything in the government to take longer to accomplish due to the coronavirus eventually.
Answering the question from Raghuveer of Facebook, the H-1B premium processing is only suspended for the quota cases. It's not suspended for the extensions, amendments, and it's not even suspended for transfer from other visas if they were been already counted towards the H-1B number. If it's only for the new quota, it's been suspended.
Sunil is a physician and occasionally has to work at an outreach clinic for his employer. Oh, we already did that one? Sorry.
And the question that comes from YouTube is L1 extension timeline and rejection percentage. One L1B is taking approximately around 8 months for the normal processing, but you do have a premium processing. I would strongly recommend to get the premium processing, get a result before your I-94 expires. I can't give a percentage. It will depend on the specialty. It will depend on the uniqueness of the job. So I can't tell you the rejection percentage, but I can tell you that the rejection percentage has gone significantly higher in the past 3-4 years. In the past 2 years, it has gone significantly higher for the L1B extension.
Motion question on YouTube. I'm applying for H1, but in June, my client site will be moving to a location 3 to 4 miles away from the current location. Will a new LCA need to be done? What's the status of that situation? So generally when a work site, like the entire company is moving office space and it's only 3 or 4 mile difference, that does not impact the validity of the existing LCA. Again, if it's within the same metropolitan statistical area, same county typically, no new LCA is required and therefore an amendment is not required. If the move is going to be outside that MSA, then an amendment would be required with a new LCA.
Asim from Facebook has this question: can I change the project after the lottery is picked up, but before the H-1B has been filed? The answer to the question, Asim, is yes, you can. There is no requirement in the lottery system at this point of time that we don't give them any end client at this point of time. So you can have a different project. I don't see that as a problem at all.
Question Anand from YouTube. L1 is expiring March 29th. Can we file a change of status to if the H1 is picked in the lottery while the L1 extension is pending? So you can, but know that on the H1 you're likely to eventually get a request for evidence asking for proof that your L1 has been extended to at least September 30th. And then if you don't have that approval, if your L1 gets denied for some reason, then the H-1B change of status portion of the petition will be denied and you'll receive a consular processing H-1B approval because you were not able to maintain your L1 status through September 30th. Indu from Facebook wants to know, will they change the way how they conduct the lottery to give more importance to CAP students to keep them in the country? No, that would have to go through a regulatory process, which they've already done last year to change the order in which they do conduct the lottery so that U.S. master's degree holders have an added advantage in the lottery process. But for them to make any additional changes to how the lottery is conducted, they'd have to go through a regulatory process, and there's not enough time for that to happen.
Srikant from YouTube has this question: will the USCIS treat H-1Bs differently if it's for-profit organization or for non-profit organization. What he meant non-profit was a credit union bank. No, Srikant, in this particular case of the credit union bank, they don't differentiate between a for-profit and a non-profit organization. What it requires to be treated differently is that it must not only be a non-profit organization, it should also be a higher education institution. In this case, your credit union bank is not a higher education institution. Thus, why you're not eligible for the H1B number waiver. You're not eligible for it. Your organization is not exempt for it.
Suresh from YouTube has recently filed an H1 extension without an end client letter and wants to know what are the chances of getting the extension. Well, I would definitely expect a request for evidence asking for the proof of specialty occupation at the end client. And if you cannot provide the end client letter, the chances of denial are quite high in that situation. It is practically mandatory for you to submit it at some point. It's okay if you didn't have it at the time of filing, but it is important to try to get that in response to the RFE.
Sanjay has filed for H1 and H4. His H1B is approved. Can he apply for the H4 EAD before H4 is approved? The answer to that question, Sanjay, is yes, you can. You don't have to wait for the H4 to be approved to file for EAD. I'm assuming, of course, you have the I-140 approval. You can file H4 EAD, and then it's taking a long time to get these adjudication. If you come and join our court litigation that we do every 2 weeks, then it will get much expedited than compared to the time it takes to get the H4 and EAD approved. You may contact our office for it.
Gertej from YouTube is graduating in May and has already applied for the OPT, and he wants to know if there will be any difficulties in the processing of the EAD card. At this moment, no. However, like we talked about earlier, there is a potential for processing times to increase, so it may take longer than normal in order to receive the EAD card in the mail.
Indu has this question that will they have a different, will they do any differentiation between the CAP students when they are in the country and outside the country? The Indu, no. It doesn't make any difference for them when they're counting for the lottery. Whether you're in the country, whether you're outside the country, it doesn't make. Of course, Indu, you already know that if they have a master's from a higher education institution which is accredited university, if they have a master's with a accredited and non-profit organization, there is definitely a difference. That's all. Just because you're in the country or outside the country, it doesn't make a difference. Even for those people who have a master's degree from recognized universities, they're outside the country, they will be given equal importance to the people who are in United States.
All right. Pooja wants to know if a change of status from H1 to H4 will take even longer now, given the current situation. That is a definite possibility. I mean, those processing times are already horrible.
Yeah, every 6 months they're increasing it by 2 months anyway. What we recommend is that if you have an EAD pending though, to join our court litigation that we file every 2 weeks to expedite the process. That's the only way that you can get it processed fast. Anything else, Emily?
I think it's about time to wrap it up for today.
Thank you, guys. But if you miss any questions, you can always contact me or Emily at rnlawgroup.com, and you can make an appointment with us or any of our good team members that we have. Don't forget to subscribe to Immigration News at rnlawgroup.com and also at Immigration Girl blog, which Emily manages it.
Thanks for joining.
Thank you.